Sometimes, to get to the bottom of what happened with an event in history, a trial needs to take place. This was the case for Will Britton, accused of conspiracy to murder James Cockrill. In today's video, we will walk through the newspaper account of both opening statements that happened during the January 18th through 26th, 1905 court session. And we will also talk about the stall tactics of the other conspirators. This will be a multi-part section of the feud, as there is a lot of testimony to go through and sort out the facts of the case. During this same time, Attorney Marcum's widow was also suing anyone that was associated with the Hargis faction, as well as there would be a Hargis trial take place for the death of James Cockrill. We will cover these three trials separately because there is a lot of information that does come out of them. As always, we will use newspaper articles and other documentation when found concerning this time in history. All aboard the Kentucky-Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine, but it convinces YouTube that we need a bigger time machine to reach more people who love history as much as you do. Now, back to our story. Jurisdiction issues. According to the report given in the Mount Sterling Advocate on February the 1st, 1905, quote, the indictment is found by the grand jury of Fayette under the statute of Edward VI, giving jurisdiction to a court in either the county in which a crime was begun or in which it was finished. James Cockrill was shot in Breathitt County and died in Fayette County, so under this statute, the court in either county had jurisdiction. William Britton, now on trial in Fayette Circuit Court, is, as far as we know, the first man who has ever been indicted and tried under this statute. Unquote. Bravo points for originality to the prosecuting attorney, A. Floyd Bird, for thinking outside of the box. The juries in Breathitt County refused to take up the cases because of witness and jury tampering and intimidation. Bird brought the cases before the jury in Fayette County to be tried. Warrants were also issued to the three Hargis brothers, Callahan, and Jesse Spicer, deputy sheriff under Callahan. So we are talking about a county judge, a deputy sheriff, and an ex-senator, all involved in this case. But because of the issues with the men being very well connected in Breathitt County, a special meeting among the judges concerned took place in Jackson, Kentucky. From the same source, quote, a Fayette official was sent on Saturday to Jackson to serve bench warrants against the others indicted for the conspiracy in this murder. He returned without making the arrests. The Hargises claimed that they were under the jurisdiction of Edwards, a magistrate of Breathitt, who some weeks ago had taken up their case, according to the entries claimed to have been made on December 3rd and 5th. Unquote. This would cause a huge quandary for the Kentucky State of Appeals as to who would have the jurisdiction of this case. Breathitt County and Fayette County would have an equal chance under the law to try the case. First, a representative of the Fayette court was sent to Jackson, Kentucky to collect the men for trial. When this was not successful, the judges and attorneys for the Hargises held a conference. Quote, the conference held here Saturday between Judge J. H. Hazelrig, Judge J. Smith Hayes, Judge Lewis McCowan, attorneys for the Hargises, and Colonel John R. Allen, representing the Commonwealth, was short and to the point. Colonel Allen taking the position that the time for the men to discuss the question of jurisdiction is after they have been arrested on the bench warrants and presented before the Fayette Circuit Court. To this, the representative of the men indicted on the charge of murder of Cockrill would not agree, and the result is the same as before the conference took place. The Hargises and Callahan continued to take refuge under Magistrate Edwards in Breathitt County. Unquote. So the first round of mediation had failed. So the judges of Fayette County decided to meet face-to-face with the judges of Breathitt County. Judges Hazelrig, Hayes, and McGowan went to Jackson Saturday afternoon to confer with their judge counterparts. Officers were watching at Winchester and Lexington, expecting the accused to accompany the lawyers when they returned on Monday. A telegram was sent from Jackson on Sunday, saying the Hargises, etc., would go to Frankfort on Monday. The Lexington Herald on Monday says, quote, Judge Hazelrig admitted that he gave out the statement himself to the Courier-Journal in response to an inquiry, and that he mentioned the fact that the Hargises would accompany them just to test the public pulse in the matter, unquote. The lawyers came without the Hargises en route to Frankfort, where on Monday afternoon they presented to the Court of Appeals a petition asking for a writ of prohibition restraining the Fayette Circuit Court from taking any jurisdiction of these cases. The resolution to this case will be discussed in our next trial concerning these men. However, the Kentucky Court of Appeals will make their decision upon this question of the law in early March 1905. Opening arguments for the Commonwealth of Kentucky. Quote, on Wednesday, January 25, 1905, the Mount Sterling Advocate reported the following. Britton on trial. Opening statement of Mr. Byrd contains sensational allegations. We clip the following from the Lexington Leader of January 18th. The case against Will Britton for the murder of James Cockrill in Jackson promises to be most interesting. When the court convened Wednesday morning, the trial began. There is a brilliant array of legal talent on either side. A. Floyd Byrd made the opening statement for the Commonwealth and was followed by O. H. Pollard, who made the statement of the defendant's case. Associated with Mr. Byrd are Colonel John R. Allen and C. J. Bronston of this city, and B. A. Jolett of Winchester. C. W. Miller and Judge James Mulligan are associated with Mr. Pollard for the defense, unquote. So, before we get into the opening statement, we have the dream team of the legal system of Breathitt County defending Mr. Britton during the trial. This was going to be a sensational trial, as other men were also facing their own trials for conspiracy. Byrd's opening statements. According to the same source, quote, the opening statement for the Commonwealth was made by Attorney A. Floyd Byrd, who has done so much to rid Breathitt County of the assassins. We expect to prove that this defendant, Curtis Jett, James Hargis, Alex Hargis, Elbert Hargis, Ed Callahan, and others entered into a conspiracy to procure the death of James Cockrill, and that as a result of this conspiracy, James Cockrill was shot from a window of the courthouse at Jackson, from which he later died in this city. Mr. Byrd then explained the law under which Britton was indicted in Fayette County, where Cockrill died, and not in Breathitt County, where the fatal shot wound was inflicted. The proof will show that Cockrill arrived in Jackson about 11 o'clock in the morning of the day upon which he was assassinated. He had been away from Jackson and had come back to get his trunk and make his home elsewhere. The day Cockrill arrived, Britton was at the home of Elbert Hargis, and that Elbert Hargis went there for Britton, and that he and Britton left together and went to Jackson. About 10 minutes before the murder, Elbert Hargis, Curtis Jett, and Will Britton were seen going up the rear steps leading to the upper story of the courthouse. Britton was seen to leave the courthouse and go to the Hargis Brothers store and then return to the courthouse. He was not seen to leave the courthouse until after the shooting. Witnesses will testify, said he, that at least 3 rifles were extending from the windows of the courthouse and were fired in the direction of Cockrill, who fell at the second volley. Raleigh Cold Iron will say that he saw Curtis Jett and Will Britton at the windows of the courthouse at the time Cockrill was killed, and from which the fatal shots were fired. Others will testify that immediately after the shooting, Jett and Britton were seen at the front door of the courthouse, and that Jett had a pistol in his hand. It will be proved that at this time, Jim Hargis was seen at the window over his store and had a gun in his hands. Proof will also show, he declared, that Jim Hargis and Alex Hargis furnished money for the defense of Curtis Jett and are also assisting Britton in his defense in the present trial, unquote. Britton's confession. Quote, says Britton admitted it. Mr. Byrd said that the Commonwealth would prove that Britton had, since the murder, acknowledged to many people that he was connected with the conspiracy to kill Cockrill, and that after the conviction of Curtis Jett for this crime, Britton was heard to say, quote, if the truth were known, I pulled the trigger which fired one of the shots which killed Cockrill, unquote. So, if everything that the Commonwealth had laid out to the jury was true, it kind of looks like an open and shut case where Britton was concerned. But was everything in line as the Commonwealth thinks that it was? Let us take a moment to go through the defense side of the story. The defense opening statement. Quote, Pollard's statement. Mr. Byrd was followed by attorney O.H. Pollard for the defense. He said he was astounded at the remarkable statement made by the prominent attorney for the Commonwealth, and that he regretted that he had risked his reputation upon a statement made which contained nothing but a lot of rot. Quote, many of the things Mr. Byrd stated he would prove, unquote, said Pollard, quote, are incompetent and will not be permitted to be proved by a court. Of the 60 witnesses who are summoned by the Commonwealth, not more than 20 will testify, and these will not say one word tending to convict the defendant of this crime. Nearly all of them are liars and perjurers, and are here to attempt to swear away the life of Will Britton. Mr. Pollard referred to the investigation of this case by the Breathitt County Grand Jury, and that no indictment was found against Britton. He charged that Mr. Byrd mysteriously came to Lexington with a number of witnesses and fooled a Fayette County grand jury into finding an indictment against Britton. The proof in the case will show that at the time of the shooting, Britton was in the office of the Master Commissioner in the courthouse and had been in that office for some time before the shooting, unquote. In next week's episode, we will get into the trial testimonies and what the papers say about them. Were they as the defense said and just lying, or were they telling the truth about what happened with the death of James Cockrill? And why has history forgotten the trials of those accused of conspiracy of this crime? The jury. The members of the jury were reported in the Mount Sterling Advocate on February 1st, 1905, after the trial had ended. The paper reports that 10 of the men chosen were Democrats and 2 were Republican. While political affiliation does not seem to play a part in most of our feuds and trials, but in this case it seems to have a prominent role. Breathitt County was already at war with itself over which political party held the biggest sway with its voters and citizens. This is the very first time that we have seen it reported, and we thought it was very interesting that it was. The jury that was sat in this case is as follows: John Shea, foreman and ex-policeman; Lee Hancock, farmer; W. H. Thompson, harness merchant; John Randolph, farmer; C. P. Foley, contractor; J. H. Dozer, dry goods clerk; John Funk, farmer; E. Endiver, carpenter; W. S. Van Meter, farmer; W. M. Bateman, contractor and ex-police commissioner; John Richardson, retired merchant; and W. H. Alexander, farmer. In 1905, only gainfully employed or property-owning men could sit on a jury. Women and others were not allowed to make decisions concerning guilt or innocence. This would change over time, but for now we see that the jury is made up of farmers, an ex-policeman, 2 merchants, a dry goods clerk, a carpenter, and an ex-police commissioner. A little housekeeping. There is something that we would like to ask our viewers and readers to keep in mind. Many of the trials in several counties were going on at the same time, or back to back to each other. We did cover as much information as we had available about the trials of Curtis Jett and Tom Smith, and are doing so with the trial of William Britton. However, These same people will also testify in the Hargis conspiracy case and the Widow Marcum wrongful death claim. The trials of Perry and Breathitt County are linked together, and many people will be seen over and over testifying in all of these cases. It would not be out of the realm of possibilities when we see the testimony given in one case, the exact same testimony was given in the next case. This is why we will briefly summarize the retelling of the testimony when newspapers list a name and say things like, quote, the same testimony was given in such and such a case, unquote. Also, please consider that in the cases of Smith, Britton, and Jett, that a lot of the testimonies given were not listed in the newspaper, but were given in much fuller detail during the two trials of the Hargis faction. There was a lot of courtroom drama surrounding the witnesses to the trial of the Commonwealth of Kentucky versus William Britton in the Fayette County Circuit Court before Judge Parker. According to the Adair County News, quote, neither of the Hargises, who are alleged to be conducting the defense, was present, nor was Thomas Cockrill, brother of the slain officer, in court, he having gone to Breathitt County to arrest Charles Robinson, wanted by the prosecution as a witness, unquote. It is unclear if Thomas Cockrill did in fact testify in the case of William Britton. We could not find his testimony if he did. However, he will show up again in later trials. We also tried to find the testimony of Charles Robinson. Charles Robinson, as we have stated before, had a warrant out for his arrest because he was considered an important witness for the prosecution. We could not find his testimony and what he saw. However, we did find where he was later involved in a political dispute and was shot and killed. We could find no evidence if this was connected to his testimony in court or not, but common sense and logic does make one question if it was so. The testimony of Mortimer Forbes. The first witness on the stand would be Mortimer Forbes of Jackson, Kentucky. Here is his testimony according to the Adair County News. Quote, the first witness this morning was Mortimer Forbes of Jackson, who said that he was crossing the street near the post office when the shooting commenced, and that, looking toward the courthouse, he saw 3 gun barrels protruding from a window. He said that he recognized Will Britton and Curtis Jett at the window, unquote. The citizen gives a bit more detail about what Forbes testified to on the witness stand. Quote, Mortimer Forbes of Jackson testified that the 3 men were at the window from which shots were fired. He recognized Curtis Jett, but failed to recognize the others. He saw Jett, Britton, Egbert Hargis, and Jesse Spicer in the corridor of the courthouse and suggested that they should go upstairs and find out who did the shooting. To which Spicer replied, quote, if you do, you will get your damned head shot off, unquote. We do not have a cross-examination of the witness available. We do not have a complete transcript of the trial, only that which is printed in the newspaper. However, it seems that his testimony was not shakeable and that it stood the scrutiny of the defense attorney. Albert S. Johnson. Here is the testimony of Albert Johnson, according to the Adair County News. Quote, Albert S. Johnson, a resident of Jackson, said he was sitting on the steps in front of the Cardwell building for some time previous to the shooting and saw Elbert Hargis, Will Britton, Curtis Jett, and Jesse Spicer standing in front of the Hargis store. Witnesses saw Britton cross the street in the direction of the courthouse and heard someone in the upper room of the Hargis store call to him, and Britton went back to the store and later came out and went to the courthouse. About this time, witnesses saw Jim Cockrill and Stuart Hager on the Cardwell corner, and just as the witness stepped into the Cardwell building, he heard the shooting begin. Witnesses did not come out until the firing ceased, when he saw Britton and Jett leave the courthouse and go into the direction of Hargis' store. While this witness was being examined, the Commonwealth had Charles Terry sworn in as deputy sheriff, and he was sent to Lee County to get Silas McIntosh, who is an important witness for the state, unquote. Again, We do not have cross-examination of this witness available. However, like Forbes, his testimony must have stood up to scrutiny. We do not have the testimony of Silas McIntosh for this trial currently. However, it is hoped that one day through digitalization that these records will one day become available. Riley Cold Iron. But by far the most dramatic of all of the witnesses in this trial was Riley Cold Iron. According to the Breathitt County News, Riley Cold Iron gave testimony previously in the Breathitt County Circuit Court against William Britton. This action would lead to a lot of trouble for Cold Iron, as his testimony must have fell apart on the stand. He would face 2 court hearings for perjury. In another Breathitt County News article, we see the charges of perjury was leveled at Cold Iron. Quote, a demurrer was sustained to the indictment against Riley Cold Iron, charged with perjury in connection with the James Cockrill case, unquote. A demurrer is an objection to the complaint or counterclaim, not a motion to dismiss. It is called because it is believed that the state has made a claim which relief can be granted. A demurrer does not dispute the facts of the case, but argues that there is no legal claim, even if the facts presented by the plaintiff are true. So in the first case of perjury brought against Cold Iron, it seems that his case was not completely dismissed, but neither was it going to end in a conviction. But this would not be the end of things for Cold Iron concerning his testimony. We get a little more detail about the drama about the testimony given and what happened about his testimony from the B article. Quote, a sensational story was told by A.C. Bowman, foreman of the Breathitt County Grand Jury. He testified that when the grand jury was investigating the case against Will Britton for killing Cockrill, for which he afterwards was given a life sentence, Riley Cold Iron had just given sensational testimony against Britton. At this point, Alex Hargis rushed into the grand jury room and by threats and angry attitude compelled the grand jury to adjourn after vainly trying to get it to investigate a charge of perjury brought by Britton's friends against Cold Iron. Bowman said the case was dropped and never resumed by them through fear, unquote. So, even though Cold Iron had went before the court concerning the testimony, it seems that Alex Hargis was fearful that the jury would take into consideration what was said on the stand. This led to the jury being fearful of Hargis's and possibly retaliation. So they dropped the case in Breathitt County against Britton. This would lead to Fayette County taking up the case for trial. In a later Breathitt County News article, we see the following, quote, Riley Cold Iron was re-indicted for perjury because he swore before the grand jury here last year that he saw Will Britton at the courthouse window when James Cockrill was killed. His case was moved to Lee County on a motion for change of venue. It will be remembered that Britton was convicted to a life term at Lexington recently. Unquote. It is unclear if Cold Iron testified in the Britton case in Fayette County because of the trouble he was having with William Britton's supporters. However, we did find it interesting that he is mentioned several times in connection with the Britton case. William Britton, Harrison Blanton, and other witnesses. According to the Citizen newspaper, quote, in the trial of William Britton for the murder of Jim Cockrill, Harrison Blanton of Jackson testified that a few minutes after the shooting, he was in the corridor of the courthouse in Jackson and that he met Kurt Jett, Bill Britton, and Jesse Spicer together. He testified that there was no other person in the corridor at that time, and that Jett pulled out a pistol and remarked, quote, well, here's what laid him out on the cooling board. I'll go and see my kinfolks now, unquote. The testimony of Harrison Blanton is another one that we do not have a cross-examination for, but it seems that his testimony did stand, as we do not see any charges leveled against him as in the case of Cold Iron. James Blanton, W. H. Pelfrey, W. N. Cope, and Sebastian Williams would all testify that they saw Curtis Jett in the window of the courthouse during the shooting of Cockrill. This would be understood that they did not see William Britton in the window at the time of the shooting. William Britton takes the stand in his own defense. Everyone in the United States has a choice whether or not to testify in their criminal court cases. William Britton takes the stand according to the Hartford Republican. Quote, William Britton on trial at Lexington for the murder of James Cockrill at Jackson testified on his own behalf and denied all connection with the killing, unquote. We do not have a list of any of the testimonies that attorney O.H. Pollard brought to give William Britton an alibi. There is no evidence given by the newspapers that Britton could have been in the office of the Master Commissioner in the courthouse during the shooting, and there is no listing for the Master Commissioner's testimony or sworn statement read to the jury that we could find. The Breathitt County Trial. As we alluded to with the witnesses last week, there was a trial for the murder of James Cockrill that did take place in Breathitt County. This was a grand jury that was gathering evidence concerning the death of Cockrill. As the witnesses were done giving their testimony and the evidence had been given, the jury went into their chambers to deliberate. Egbert Hargis burst into the jury chambers and basically threatened the jury not to consider the testimony of Riley Coldiron in the case. Through fear and intimidation, the jury closed the case and would not deliberate further, which caused a mistrial. Thinking that the cases were finished, those in Breathitt County thought that they would have to face no further charges. That was until the cases began opening up in Fayette County, Kentucky. Because Cockrill had died in Fayette County, this left the door wide open for the cases to be brought before the county courts there. The Hargises had no political sway in the county, so it was thought that this would be a fair trial. Many motions would be made to dismiss the cases, and the appellate court of Kentucky would have to rule on the matter. Jury passes judgment. In the Fayette County Court, the witnesses all had testified. The public testimonies can be found in Part 2 of the trial of William Britton, and the evidence had been presented. Now it was time for the jury to deliberate. This took several days. Finally, the jury came out of the room and gave their verdict. According to the Hazel Green Herald, dated February 2, 1905, quote, Britton gets life sentence. Unless the Court of Appeals reverses the Fayette Circuit Court, William Britton must end his days in the penitentiary with Curtis Jett for the murder of James Cockrill in Breathitt County. Quote, We, the jury, find the defendant guilty as charged in the indictment and fix his punishment as confinement in the penitentiary for life, unquote. John Shea, foreman. Thus, a Fayette County jury yesterday condemned the second of the band of conspirators and assassins which have terrorized Breathitt County and brought to a dramatic close another chapter for the struggle of the law for supremacy. When Judge Parker arrived and the jury filed slowly in, Deputy Circuit Court Richard Colbert received the verdict from the hands of Judge Parker, to whom the foreman of the jury delivered it, and read it amid profound silence. At the word guilty, the defendant and his attorneys were visibly affected. Lexington Herald, unquote. This was a shocking verdict to the people who were present in the courtroom. For the first time, someone who had not been directly identified as the shooter was being charged with conspiracy of a crime. The attorneys of the case rose for an immediate motion to dismiss the verdict and ask for a retrial. From another article in the Breathitt County News, quote, Britton refused new trial. The motion for a new trial for William Britton was overruled last Saturday, and Britton was sentenced to the penitentiary. But a stay of proceedings was granted for 60 days pending an appeal to the Court of Appeals, unquote. So Britton remained in the Fayette County Jail for the next 60 days until a decision concerning the case could be heard before the Kentucky Court of Appeals. Since the answer from the appellate court did not happen until the following October, it is supposed that Britton was taken to the Kentucky State Prison for incarceration. There would be two rulings from the appellate court, almost back-to-back concerning the conspiracy case. The first was concerning the right to try the Hargis brothers and Ed Callahan in Fayette County, Kentucky. The first Court of Appeals decision. In the Hartford Republican dated March 17, 1905, quote, The decision of the Court of Appeals, which gives to Fayette County the jurisdiction to try James, Alex, and Elbert Hargis and Ed Callahan for the murder of James Cockrill, Marshal of the town of Jackson, Breathitt County, in 1902, marks an important step in the progress of law-abiding citizens of the state to redeem from the depths of legal prostitution to which corrupt method and clique rule has precipitated a growing and prosperous section of Kentucky. The facts concerning the crime for which the county judge and a member of the state Democratic Committee, an ex-state senator, and a private citizen, all three brothers, and the sheriff of Breathitt County are all in Fayette County Jail awaiting trial, are brief but without parallel." Unquote. The rest of the article basically states that the men conspired together to instigate the crime of murder of Town Marshal James Cockrill. They were now arrested and in the same jail cell with Caleb Powers, who was incarcerated for alleged conspiracy in the Goebel assassination. A $100,000 bond had been placed in order to secure a fair trial and had been placed against the men to prevent the four of them from using money to sway the decision. A failed escape attempt. Yes, believe it or not, William Britton, just like many of our other Appalachian outlaws, does try to escape from prison. After sitting in the Kentucky State Prison, Britton must not have seen any hope for his case being tried before the Kentucky State Appellate Court. According to the Breathitt County News in the May 25, 1906 edition, quote, "Britton fails to escape. A wholesale attempt at jail delivery was made at Lexington at an early hour last Saturday morning, and had it not been for the bungling effort of Richard Yelton, Bill Britton, under the sentence for life for the murder of James Cockrill at Jackson, and Benjamin Stewart, charged with the murder of James Stewart at Lexington, would perhaps now be free." By the use of a case knife which he used as a saw, Yelton, a trustee, cut the bars on the third floor of the jail, and with a rope made from strips from his blanket, he attempted to lower himself to the ground. He fell, and the noise made by the fall attracted the attention of people nearby. Yelton escaped, but the crowd which gathered kept Stewart and Britton from getting away. Unquote. So the three guys that were in the prison had broken out of the jail, but because Yelton had made a noise when he fell to the ground, it alerted people around him, and the other two men were recaptured and taken back to their jail cells. This would be the only attempt made by Britton to escape, as recorded in the newspapers. Reversed decision. Even though Britton had tried to escape, the decision for his case before the appellate court finally came in October of 1906. Britton would indeed have his retrial. This would make the third time that Britton would face the jury over the crime of the murder of James Cockrill. The first time was a hung jury in Breathitt County, and the second trial was in Fayette County. According to the Hopkinsville Kentuckian on October 6, 1906, quote, "The Court of Appeals has reversed the life sentence of Bill Britton, one of the convicted murderers of Marshal James Cockrill of Jackson nearly 5 years ago. The admission of incompetent evidence was given as the grounds of the reversal." Unquote. According to the Bourbon News on October 6, 1906, quote, "Britton gets new trial. The Court of Appeals by Commissioner Carroll yesterday reversed the judgment of the Fayette Circuit Court in the case of Bill Britton versus the Commonwealth. Britton was given a life sentence for the shooting of James Cockrill at Jackson in July 1902. Cockrill having been removed to Lexington where he died, thus giving Fayette County the right to try the case. The case was remanded to the Fayette Circuit Court for retrial with instructions. The ground of reversal is incompetent evidence. Unquote. It is really not stated if they took into account the testimony of Riley Codiron or not, or if it even had a bearing on the appellate court ruling. A ruling of incompetent evidence means that a piece of evidence that was not relevant, immaterial, or had no bearing to the case at hand was admitted into the case before the jury. So this could have been the evidence against Codiron, or it could have been that Britton was wanted in Lee County, Virginia for the 1899 murder of a man there. Whatever it was, evidence was omitted that should have never been presented or should have been struck from the record. Britton faces new charges of murder. Britton must have felt relief that he was going to be set free from the Kentucky State Prison to face a new trial. However, this feeling was not long-lived, because as soon as this ruling was made, 2 other counties stepped in with warrants for Britton's arrest concerning the other 2 killings. According to the Mount Sterling Advocate, quote, new warrant ready for Bill Britton. At Lexington, Kentucky, a bench warrant from the Breathitt County awaits Bill Britton when he gives the bond of $7,500 fixed in the case against him for the murder of James Cockrill. The Breathitt warrant is for his arrest on the charge of complicity in the murder of Dr. B.D. Cox at Jackson. James and Elbert Hargis and Ed Callahan are also charged with Dr. Cox's murder, unquote. We will get more into why the conspirators were tried for the murder of Dr. Cox in the wrongful death case of Attorney Marcum. More evidence of the conspiracy will come to light, and it will cast a long shadow on the next jury trial of Britton. In the May 31, 1907 edition of the Breathitt County News, quote, Bill Britton, taken to Sandy Hook for trial. William Jenkins of the Lexington Police Department left Lexington for Sandy Hook, Elliott County, last Saturday, having in charge Bill Britton. Britton recently executed bond in the Fayette Circuit Court for the murder of James Cockrill and will execute bond for $10,000 in the Elliott County for the murder of Dr. Cox. He was accompanied to Sandy Hook by his wife, who had spent much of her time in Lexington since the arrest of her husband. The Britton party were met at Moorhead by James Hargis and others from Breathitt County, and the trip to Sandy Hook was made by wagon Sunday. Britton was delivered to the jailer of Elliott County Monday morning and immediately executed bond with Alex Hargis and G.W. Swall as sureties, unquote. According to the Winchester News, quote, L.L. Britton goes to the state of Virginia. Is taken there by Sheriff of Lee County to answer charge of murder. W.Y. Tucker, Sheriff of Lee County, Virginia, passed through this city Wednesday morning on his way from Moorhead to Virginia, with Bill Britton, who is wanted at this place on the charge of murder that it is alleged that he committed by him in 1899. Britton is also charged with the murder of Jim Cockrill at Jackson several years ago and is now out on a $10,000 bond, unquote. From here, the story of the trials of Britton takes an unusual turn. While the Hargises and Callahans were fighting against being arrested for the same conspiracy that Britton was convicted of, they were also fighting against the widow Marcum and the Cox families for the murders of their family members. We will first dive into the lawsuit brought by the widow Marcum and how this will bring more evidence and arrests in the bloody Breathitt County War. Thank you. We at Kentucky Tennessee Living would like to thank you for watching our video series on the Appalachian feuds. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification. We thank you for continuing to support Kentucky Tennessee Living as we are discovering the mysteries in Appalachian history.